Hi everyone, it's Grant Abbott and welcome to the first official launch of LYProtect in Australia, which is essentially it's a set of tools, documents, automations, resources, strategy support around the three core areas that I believe are the big go-tos over the next 20 years. That's succession, asset protection, and also estate planning. And really, we're going to see a whole range of new advisors coming out of the accounting fraternity, out of the financial planning fraternity, who will really take this on and become what I call a SAPEP, a succession, asset protection, and estate planning guru. I certainly know my friend Tim Munro is right in that ballpark already with some of the stuff he's doing around asset protection and using the protector. So that for me is where we started to think about building a little island within the LightYear Docs platform. We've got more than, it's surprising, we haven't even been going a year now. We've got more than 75 to, I think it's coming up to about 80 different documents on the platform. But for those who are using it, like the protector, the moat for estate planning, and our new LYD wills and EPOAs, where you'll actually be able to do them for a family, not just mirror wills, but for a family. You'll understand that the power of our platform is in the automation, making the ability to do multi-documents in a heartbeat. And certainly what we've done is we've found this really high-end niche for us and also for you guys in terms of building a range of succession, asset protection, and also estate planning strategies, and combining them all in through automation. So it's very exciting, and certainly it's well and truly overdue in Australia. Now, I was going to put here Houston, we have a problem, but Australia, we've got a huge problem with our legal fraternity. And I know my partner, Tony Animoulis, doesn't mind saying that because we see it day in, day out. And Tony's motto is always to look, if you end in a litigation, the best thing always is to get to a mediation, negotiation, and don't ever get to court. If you get to court, it costs hundreds and thousands of dollars. So you can see here, this was a 2018 case. It started in 2013, and you've got Justice Jeremy Courtois there, who is a Supreme Court judge in the Western Australia. And you can see there he launched a scathing attack on lawyers who feasted on a small family estate with their indefensible legal fees, describing it as a scandal that brings the profession into disrepute. Justice Jeremy Courtois' withery takedown was aimed at the lawyers involved in the case of Angela Miller, who was contesting the will of her late de facto partner, Andre Taylor, who left his entire estate worth about $600,000 at the time of the three-day trial last October to his two children, Elizabeth and Philippe. In a recent judgment, it was revealed that combined legal costs were potentially more than $500,000. In fact, the whip was $570,000 in a case involving 6 lawyers, one from interstate, but which only should have had 2 according to the judge. The smaller state had been ravaged by legal fees, he said. And that's fairly typical of an estate planning case, which my issue is that many of our clients go to their suburban lawyer or even a high-priced lawyer to get their estate planning done. Now, the problem about that, and you all know very well, is that that's a once-off transaction. Now, you might go and get an EPOA done with a local lawyer, which really is a draft of the, for example, the draft of the various state-based EPOA documents, which apply obviously during life. Now, if you go and get a will, you might be paying anywhere from $500 to $1,000. But as soon as you put a testamentary trust on, you're looking between $1,800 to $3,000 for a will. But that's the only transaction involved in those. And it's quite funny when you have a look at the documents that usually the opening lines of a will or a testamentary trust, and let's face it, lawyers don't create documents themselves. They use what we call as precedents, stuff that other people have created, which I don't like anyway, because I'd prefer to create my own, and that way I can start to build strategies in. It's very difficult to build strategies into something you really don't know much about. But usually the opening stanza of a will, you'll find in the first few paragraphs that the executor or the estate is being given the power to control a family trust or a self-managed super fund, or at least have an impact on the trustee, which is 100%. In fact, if I could go above 100%, 1,000% wrong at law. There is no way in the world, unless you've got a well-drafted, combined, strategic jigsaw between a trust and also an SMSF and the estate, that they can all actually be treated as one. Of course, I've built a wide range of documents to ensure that's happening if the client so desires. And effectively, if you can do that, then you've heard me before, you can put a moat around your client's affairs. Because when it comes down to estate planning, if this $600,000 was sitting in a discretionary trust, most of you would be well aware that this would never have been an issue. The $500,000 plus charged by lawyers wouldn't be an issue because it was actually sitting in a discretionary trust, which for me is our ultimate goal. But you'll generally find that lawyers don't do that. They prefer to work on the will and in somehow try to inveigle themselves into the SMSF or the trust where they don't really belong. And so for me, that's a big problem, because one of the issues there is that as we go down and have a look at some of the issues, is that family provisions claims. Now, every state and territory has the ability or has usually a section inside their Succession Act or their Dependents Act enabling eligible persons to make a family provisions claim. Now, I've taken this out of the New South Wales Succession Act 2006 and just paraphrased it. I'm doing a current article for SMSF Advisor on this and really starting to drive into the fact that we as advisors need to extend ourselves beyond accounting, beyond planning, or beyond SMSF, and effectively work ourselves into estate planning, succession, and more importantly, asset protection. In fact, for many of the ones that I've done with my partner, Tony, lately, we're not spending much time at all in terms of wills and estate planning, but more on the asset protection side and building family protection trusts so that at the end of the day, there's not much left in the will at all for a family provision challenge. Anyway, let me wheel back around and have a look at the family provision side of things. Generally, in New South Wales, and it's much the same for all other states, is that a family provision claim can be made within 12 months of the date of the death of the deceased, which is why you will see in the local suburban newspapers, I could just go on straight away and pull up maybe at least 50 legal sites across Australia where there's a no-win, no-fee lawyer who'll be involved in the process. As you can see from the Miller and Taylor case, it's a beautiful little gravy train that lawyers can get involved if they're litigating. And remember, they're litigating, a lawyer's actually provided or produced a will and testamentary trust previously. So it's quite an interesting paradigm there that it's all kept within that legal fraternity. Now, what will happen there is that you've got that 12 months, which really means that they're out pushing very hard. And once they can latch on, then they'll latch on really hard. Now, an eligible person includes a wide range of claimants, including the wife or husband of the deceased, a person who is living in a de facto relationship with the deceased, a child of the deceased. Now, this is interesting, a wife or husband of the deceased. In Kelly versus DeLucci, which was a 2012 case on notional estate, which I'll talk about a little bit later, which is a separate little section of the New South Wales Succession Act. And I'll cover that later. What the lawyers there did is they started to hunt around, because this was the third marriage of the deceased. They started hunting around for the other former spouses, because obviously if every spouse has a potential claim, then you want to find. In fact, they found one which was a Filipino bride of the deceased, the second wife, who ended up going back to Philippines 27 years ago. And they tried desperately to find her, but they couldn't, unfortunately for them. Otherwise, she would have been a party to the estate. Now, as an interesting sidebar to this discussion, she was not only a bride in Australia and was out here for only 2 years. She ended up going back to the Philippines because, lo and behold, she was actually married in Manila, so that she had an existing husband. So effectively, she was a bigamist, and that's why she turned back to the Philippines. But they still tried to look for her because she was able to claim under the Family Provisions Act. You can see there also another person who can claim is a person who is wholly or partly dependent on the deceased. So that, for example, could include brothers, sisters, anyone who may well be an interdependent, or as a grandchild of the deceased, or was at the particular time a member of the same household of the deceased, or a person with whom the deceased was living in a close personal relationship at the time of the deceased person's death. So the net for a family provisions claim is wide open. Now, the major problem that we've got with that is that we see that usually a lot of these claims really because the estate plan, as I said before, is focusing on wills and testamentary trusts, and there's really not much discussion on discretionary trusts or SMSFs. Now, of course, the lawyers, as I said before, try to drag those in, but there's no validity to those because they're actually trusts. And you'll find that an EPOA and also a will cannot direct a change in trustee. So it has to be done at the corporate level if it's a corporate trustee, or down at the trustee level, and has to be embedded into the discretionary trust, or alternatively into the SMSF. And they're sort of mechanisms that we've built over our estate planning area. As I said before, generally lawyers use legal precedents. They're not trained in trusts, SMSFs, and most of you have had experience with lawyers, and you'll find they're definitely not trained in taxation. One of the things that you'll hear me, if you go down this LYProtect route, is one of my favourite tools is to, rather than pass SMSF assets to the estate, if you've got an adult child, is effectively to create what I call an SMSF death benefits trust. And from all the reading I've done, and particularly section 102 AG, that provides that excluded persons, that is children under the age of 18, are accepted from the child penalty provisions if a trust comes out of a will or estate, but it also includes for a trust that comes out of a superannuation fund. So I'm doing a lot of work on those death benefit trusts, which I find a very exciting tool for where we go. And we just have to make sure that we marry it up very carefully with section 62 of the SIS Act, which is the sole purpose test. And that generally throws most lawyers out because their preference is to throw everything into the estate. And then, of course, that's where we have the family provisions issues. Now, one of the problems about it, and you can see it definitely in Miller's case, and look, even just the other day in the Victoria Supreme Court, the Appeals Division in Wareham versus Marcella, that these sort of cases don't happen within 6 months. This is not like a magistrate's court, which even though they take a long time, they take years to get through the Supreme Court system, and they're going to cost at least a minimum of $50,000. Now, years and a minimum of $50,000 means that if you are representing a party, effectively lawyers, professionals, they don't do no win, no fee for any reason. And I can assure you, I know my mate Tim Munro, there's no way in the world he'd do a no fee on anything, which is pretty important. So they don't go into it unless they've got a really good understanding of the case. And given the fact that eligible persons is wide open, and we're looking at small benefits of perhaps only $600,000 or more, then we're in a really good position there that you can see that the lawyers will be attacking. And what our goal is to put a moat around so that the lawyers don't attack. And I want to take you through those sort of things there as well. Now, unfortunately, SMSFs are not immune. In Wareham versus Marcella, I keep on calling it Masala because that's an old drink. When I was at the White Horse Inn many years ago, my first ever job was at a Botlow, and I remember the winos, as we used to call them those days, would come and get either Masala, brand of vino, or a flagon of port. So I keep on calling it Masala. But anyway, in Wareham versus Marcella, effectively the trial judge ended up booting out the trustee. The trustee of the fund, effectively, which was the wife, and there was no binding nomination, was held to be invalid, effectively paid everything to herself. And her lawyers said, look, there was no right or reason or rhyme for that. In fact, it was surprising they didn't, in the case, argue Katz and Grossman. In fact, I saw an article by DBA Lawyers this morning, and they were trying to justify how Katz and Grossman was different from Wareham versus Marcella. And there's one easy, they're twisting themselves in knots, but the easy one is one's in New South Wales and one's in Victoria. And that's the unfortunate thing, is that we've got different jurisdictions applying different rules. In Marcella case, they effectively booted out the trustee and put in a new trustee on the basis that she really didn't take into account all the features and make sure that every dependent was looked after. So she didn't abide by her trustee duties, wasn't under family provisions or SMSF provisions. It was acting as a trustee. So that was an interesting case, and shows that we've now got lawyers have now got an opportunity wherever there is not a binding death benefit nomination that is not valid. If you have a look at cases like Katz and Grossman, Donovan, a lot of these nominations were effectively invalid. In fact, I would say that probably about 90% of B2BNs in Australia are not valid because they don't tie in with the underlying processes in the deed. Generally, you'll find that most deeds require a B2BN. Again, everyone's using a precedent, and it has to be approved form. So if there's no approved form, you need to have a declaration or a binding resolution by the trustee to adopt an approved form. That if you haven't got an approved form, then there's no way in the world, it doesn't matter what you do, any binding death benefit nomination is effectively going to be valid. Now, New South Wales have even taken a little bit further. You see in the family provisions that I looked at a little bit further around the estate, where you can go to the Supreme Court and start to attack the estate. In New South Wales, they had they've got this idea of a notional estate, whereby on death, if a trust is created, then effectively the court can take into account any monies that are actually transferred in that trust. And that's where they've started to attack the self-managed superannuation funds. In Kelly versus DeLucci, which I've done quite a lot of writing on that. I believe that should have been taken to the High Court on a constitutionality issue, but that will be sometime down the track, I guarantee on that one. But effectively in this one, the court actually dove into the whole of the estate, and also started to dive into the self-managed super fund. So the trustee of the SMSF, who was the spouse, had to pay an amount to children from the former marriage out of the SMSF monies. So we've got a couple of cases there that are really breaking open the gates of SMSFs, whereas 5 or 6 years ago, I would have said that self-managed superannuation funds were pretty well exempt, which is one of the reasons that we need to ensure that we have really strong rules, and more importantly, we clean up that self-managed super fund very quickly upon death. It should happen straight away. And of course, for me, the best one of all is the reversionary pension. Simple, quick, and also efficient. On death, bang, it's gone over to the next person. And then there can't be a challenge because it doesn't belong in anyone's estate. It goes to the next person. In fact, you can have multi-generational reversions so that the pension effectively falls. it never actually becomes a capital of the pension member. You can put in limitations like an allocated pension. But again, that's for some time when I come around and train you on a lot more estate planning. I spent 2 days up here in Sunshine Coast training a lot of people on being succession, asset protection, and also estate planning advisors. So when we structure for succession, if we have a look at it, we've got our 3 big structures that we like. We've got our wills, and generally for most people, it's going to be their family house, their investment properties, their shares, their cars, their personal effects, golf clubs, jewelry, crockery, paintings, artwork will all be covered inside a will. Now, quite often you'll see that the lawyers will seek to take all the money from the self-managed superannuation fund. So it may well be a BDBN that goes from dad to mum, and then when mum dies, it goes over to the estate, or vice versa. Or if they both die together, it goes over to the estate. Notwithstanding the fact that adult children can be paid out directly, or as I said, we can create an SMSF death benefits trust down here, the precedents that these lawyers are using take it over into the estate. So suddenly we might have a reasonably small estate, which might just be the family home, much like Andre Taylor, might be worth only $600,000-700,000, but sitting inside the SMSF, where we've all gone out of our way to accrue a large part of our client's wealth, ends up getting diverted into the estate, where it suddenly bulks up that estate and really makes it a prime candidate for a family provision challenge. And you'll find that there'll be a lot of sniffing around to find anyone who's an eligible person who believes, one, and it's their belief that they have been left out of a will, or alternatively, the will didn't look after them in an appropriate way. You'll find in that Kelly versus DeLucci, it's quite a long case, and if you want to get access to it, I'll send you all these slides anyway, so you have a reference. But it's worthwhile reading it, and the judge went through and spent probably about 30 or 40 pages going through everyone who was an eligible person and seeking who really should have been looked after in the estate, and more importantly, to what quantum. And that was one of the reasons that they didn't have enough money in the estate. So the judge, through the notional estate, dragged the money out of the SMSF, even though it wasn't transferred over, dragged the money out of the SMSF and put it into the estate. So it was like a bargaining chip. Now, of course, over on this side, this is my favourite, which is the discretionary and family protection trust. Those vehicles themselves sit outside wills, which is fantastic. And it's a really important point. And we've also got here a bucket company. Now, a bucket company, we've got to be very watchful of a bucket company. I'll come back to that a little bit later on, because essentially a bucket company is shares that, unless they're held by the trust, which they should be, unless the shares are held, then effectively they're going to find their way over into the estate. The other danger that I've seen is trustees. We've all done the right thing and put corporate trustees up here for the trust and also the SMSFs, only to find that the shares of those vehicles are actually sitting inside the estate, which means that any litigant, or more importantly, litigant solicitor, can effectively put a pretty big stop on the executor utilising any protections or utilising that trust rule. So effectively, you can grind an SMSF and a family trust to stop, much the same way as we've done in Australia with COVID. You can grind them to a halt simply because you control the shares inside the estate. Now, obviously, with our leading member, if we have a look at our leading member corporate trustees for SMSFs, and also for discretionary trusts, in those instances, what happens is on death, the shares that are held by the leading member / appointor, or the leading member here and in the SMSF, are cancelled, so they do not go there, and the next leading member starts to take those shares, their newly issued shares. So there's no transfer, it's newly issued shares. Now that starts to bring in that succession play. So I want to follow that one. That succession play is, to me, is the key, the golden key to the success of any good SAPEP, that's a succession, asset protection and estate planning. Much the same way as the plan in the royal family of going from the Queen to Charles to William to George, that lineage there is a succession plan that is extremely effective and also very powerful and also secure. If we get our succession right with our clients, then that it's very easy while they're alive to build up their EPOA. And you'll start to see coming out of this later on this year, we'll start to be doing SMSF living wills, where there'll be a set of directions that are binding on the trustee of an SMSF on how to look after a member who is incapacitated physically or mentally inside that fund. So basically it binds the trustee. So that will be coming down to the estate plan a little bit later on. But we've got to get your head around the whole lot of stuff. So effectively, love these ones here, love the trust in terms of protection, asset protection, but also I should put there asset and also family provisions protection, and also SMSFs. If they're done correctly, we're in a good position. But bearing in mind, we've still got those nasties being the Marcella case, and also more importantly, having a look at Kelly DeLucci versus DeLucci. But remember, that's New South Wales only at this stage. So what's the solution? First off is, one of the areas there is that more often than not, accountants and also planners will tell their clients to go and see their local family solicitor, and I've gone through those issues. As I said before, it's a once-off transaction. And you already can see now, and I know Tony has got a wealth of knowledge in this area of a lot of people in large firms and smaller firms and suburban firms. Their work is dried up because effectively they rely on conveyancing, they rely on once-off transactions. Whereas when we have a look at accountants, you guys are actually the reverse. You're probably working 24 hours a day. And I know Tim certainly has, and there is no weekends anymore. And the reason for that is that you are involved in all the client structures and also strategies. But for too long, we've sort of put that estate planning aside because we've been too fearful to go into that. Notwithstanding, we know what the whole structure effectively is for our clients. And financial planners is the same sort of thing. Financial planners know really what to do with superannuation, and many financial planners are really adept and understanding in terms of estate planning, because that's basically a core part of their RG 146 to understand what happens with estate planning for shares, what happens to estate planning with managed funds, and also superannuation. And I think that that is a really good tool. Now, the best thing about it all is that accountants and financial planners score very highly. If I show you this little, I think I've still got this article here. I think I've got it here. Maybe not this my Hilton. Okay, so now I don't mean to see this. This is from the Australian Lawyer, and don't worry about the headline there, which is again, it's a very attention grabbing. But what I wanted to put out here is there was a study done over the US, is that when we have a look at it in terms of warmth and competence, the lawyers, as you can see down here, were very competent in terms of their profession, but they're not very warm. And I think most of you would have dealt with lawyers, would know that that warmth doesn't come through. Unfortunately, they're on the same level of warmth as a prostitute, although it's quite funny, the competence level there is, I'm not sure what they mean by competence. Whereas when you have a look at planners and accountants, they're up in this level here. They're extremely competent, but also they're very warm. And I think that's a very big takeaway from that perspective, is that when you're dealing with estate planning, you're dealing with families, and whether you choose, which we're going through a lot, whether you choose to build a family protection trust to really take away from a will and testamentary trust, then effectively you need to work out what it's for. In fact, I dealt with some people last night, or 4 people who went through the old Google trying to work out what trusts were for, and really didn't understand what a trust was. But when you explain that is there to look after the lineage or the bloodline, and that effectively you can do virtually anything you want inside the trust. Plus, it's extremely tax effective. Once you do that, and asset protection, keeping out the ne'er-do-well child here or that, and that's where the family trust actually fits in really well. So what can accountant, when we come round to looking at all of this, so we've got our three structures here. So we've got our trusts, we've got our SMSF's company, and we've got our wills. So what can an accountant and a planner do? Well, effectively, they can provide advice on tax. And many planners have gone through the TPB and got their tax agent requirements. And you'll find as the reverse is, if you haven't seen it, have a look on the LightYear Docs site, and you'll find there I've done quite a big session on the exemption for accountants when it comes around to self-managed super funds if they're a tax agent. So there is a lot of stuff, and you can see, obviously we had to bend over with this release of the $10,000 under compassionate grounds. That's one area they gave some conditional relief. But generally, if you're talking about tax, if you're talking particularly about estate planning or what to do with your SMSF in the event of death, those sort of things you're able to advise on, so there's no problem. Now, one of the big issues is in terms of the provision of legal advice. So we've had advice from Tony, and also if you have a look at that session that I did, if you're simply drafting a will for your client from a data capture, then in effect what will happen there is that you're simply taking some data that's taken on admin form, and then it's placed into a will. So if it's a very simple will and a data capture, then there's not really an issue there, particularly because you'll find that you can only insert information in that follows the templates that have been drafted by Abbott Mourly. Now, what will happen is there is potential family provisions challenges. So when you're doing that, essentially you'll find that if you do have, when you do go through your clients, and you'll find as part of the letters of engagement that we have available for you as an LYProtect person, is that if you do have any of these, there are, like the client has been effectively has had children before, children from a former marriage before, they're on their second or third marriage, they've got a disabled child, or potentially someone's going to make a claim on the estate, then effectively what we want to do is we're going to probably need to go down the wills and testamentary trust, or use the protector and a family protection trust, either one. But it's really up for the client to decide. But once you start getting into that tailoring of the issue, you'll still be able to do a large amount of the data capture, but that's where you'll start to liaise with Abbott and Mourly for that final sign-off, checking that, have you really fitted in there? And more importantly, doing that final Zoom with a client where Tony or one of our legal team can then go through and explain it. Do they understand this? Do they understand that? So that's a fairly big issue. We're not in the practice of making you use our legal services all the time. It's more just to ensure that when you're going down, you're potentially getting that family provisions challenge, that it's really, we're starting to block it out. And it may well be the case, which we've done a number of cases, is that the will and testamentary trust, or we don't do a will, you do a basic will, because there's not much left in the estate, which we'll talk about. So obviously you can prepare a binding death benefit nomination, or we call it an SMSF will, which is a set of directions. And you can build a family protection trust and asset protection, so there's nothing in the estate to challenge. So these are all available tools for you. So I'm going to take you through LYProtect and just show you and explain a couple of things. First off, it's up and running now, and the monthly fee is $3.95, which, when you have a look at it, to me is absolutely ridiculous when you consider that's the sort of price that a lot of your clients are paying for one EPOA. So that if you're going down this track, it's a really strong set of tools there for you. It's unlimited access to all our succession, asset protection, estate planning platform, and it really is there to make a difference. Now, you're still going to have access to, for example, someone like Tim's already on the top level of our membership. So he's a LY strategist, so he doesn't need to worry about this necessarily, because he wants to use the company's trust, etc. But for a financial planner, or you may well be on a good deal with someone else in terms of your companies who want to use other people for companies. But if you want to get involved in this estate planning area, you can just simply choose this and use all your other stuff if you want to continue to do so. Now, it's no good actually just giving you all the documents, and that's the problem, is that we see it throughout as a document means nothing unless it's strategic and you've been trained up on it, you understand it. So we've got heaps of training videos, more than 20 SAPEP training videos on the site. You've got full access to our strategy support, and whether it's both myself or alternatively it's Tony, you can just simply contact us or email us, as we do all the time. And then if you want to hook up for a meeting, just to go through some issues, and then we can put a proposal to your client if need be for that perspective. Or if it's just you going down that track and doing a will and testamentary trust, and you want to find, you've got some specific angles, such you want to set up a disability trust or something, then that's the time then to come to us. Each month I'm going to be doing 2 trainings, maybe even more, and both will have CPD attached to them for CPD. And essentially, the first one I'll go through a bit of a technical issue, and it may well be, for example, family provisions claims. I'll go through those. But then what I'll do is the next one, which will be a week or 2 later, what we'll do is I'll give you a case study in between for you to work on, and then I'll come and build a solution to that case study, so that you're always you're looking at the issues, you're looking at the law, the aspects around that, and then what we do is we then start to apply it from a case study perspective. So it's the Harvard way. In fact, it's a bit beyond the Harvard way. It's the Socratic method, which started with Socrates, thousands and thousands of years ago. So that's all included in LYProtect. There will be accreditation as a SAPEP advisor, so you'll be able to put something up on your wall. For those people who came to our course in, I think it was in March, that will certainly be on the cards for you. But we're breaking that course up into formal qualification, and that will start in May 2020. So that'll be pretty exciting. Anyway, that's probably enough talking for me. Let's go and have a look at what we've got. I don't want to look at the thing. So what we've got here is, you can see here I'm logged in as LightYear Docs demo, the LY strategist. You'll see there's a change. You can always get your EPOA and enduring powers of attorney. They're only $99 each if you want to do that. But if we have a look here, we've got our LY Basic, which is just sign up and you get your documents from $49 or $99. You've got there the LY Firm if you just want to do documents. If you want to do CPD staff-wide, then you're on the LY Strategist. But if you just simply want to do estate planning, just sign up as LYProtect, which is $395 a month. So just sign up, you're off and running, and then you'll be able to access our estate planning. So when it comes around to the estate planning, we've got a whole lot, and I'll go through each of these quickly so you understand. The first one is the dependency declaration. So this is a declaration made by a member of the fund to the trustee of a self-managed super fund, saying that this grandson or this child or this person, my brother or sister, is financially dependent or is a dependent of mine. Now, if they're a spouse or a child, you don't need to worry about that because effectively they're caught under the SIS Act. But if you're looking at for tax purposes, then a child, if they're over 18 and they're not financially dependent, then effectively you're out of the ballpark. But here, if we can show that our brothers, our sisters, our children, and there's quite an extensive ruling from the Commissioner on this, that if we can show they're partially dependent, then in effect, when the monies are paid out if I get back to our little diagram here, my favourite, when the monies are paid out of the SMSF directly to the adult or the grandchild if they're financially dependent, and so financially dependent means they're a dependent for both SIS and tax law, then when that comes out, it's going to be tax-free. Ordinarily, as I said, the traditional is we transfer it into the estate, into a testamentary trust, and it will be tax-free. So that one document can make a huge difference for your clients. And that can be also bundled in with our family allowance agreement. And what that is, it actually provides a framework for a cogent, an allowance paid. Generally, a lot of parents and grandparents look after their kids' school fees, look after this, but they look after it directly. If we can show continuous, ongoing money's being paid to a family, then potentially all of that family is financially dependent on the grandparent or so on and so forth. So that's also a great tool to use that and that as well. Now, the enduring power of attorney, we've got that, and we've now just gone through a process which is pretty, well, as far as I'm concerned, is right up there. So that we've now got a position that we can go one step beyond, and I might just pull this up and I'll show you my vault. If I have a look at the conference here, I've got a New South Wales EPOA. I'll just have a look at this. I think you're going to love this one, Tim. It's one of my favourites now. Again, we're always building, thinking. No one else in Australia has this at all. So obviously you got your principal, you got your attorney, substitute attorney. Remember, we want succession. And you'll find really, once I start to do this for the EPOA, generally it's going to be exactly the same position for executorship in the will. Now, when I come around to the power of attorney, we've got here a third one, which is, I worked with Tim to actually, as I said before, your EPOA or your will can't direct what happens into a company. But what we can do is we can put in a specific clause within our EPOA where the principal effectively says, I would like these people who hold my enduring power of attorney to be directors of a company that I happen to be a director of. Now, again, if it's a closely held company, or even if it's not so closely, we'll then have to go to the board of directors, and you'll find there for that company, out will pop resolutions from that company. So it's binding under the Corporations Act that will put in place these alternate directors, being the EPOAs, when the principal is no longer able to manage for themselves. So again, that's pretty unique and goes beyond a sole director to actually make sure that you're looking after your interests, even if you're just one director of many in a business, but you do hold shareholding in there. Now, obviously, we can put in our powers of attorney, how it goes. We've also got now to be able to put in giving gifts to the power of attorney. And giving an amount of money for the reasonable living medical expenses. So there's quite a lot of terms and conditions. So that's an exciting one for me when we have a look at our powers of attorney. And again, it's just something that has only gone up. And I'm going to have to give a session in a couple of weeks of all the new features that we've built over that time. So anyway, in the LYProtect, let's go back through. You get full access to this. Buy-sell option agreements. Again, this is a succession issue, and it's really absolutely important. It has to go into the estate planning. If you haven't seen it, you'll find, again, you can go into our strategy centre here, go into webinar and training videos, and you're going to find a lot of these articles basically sitting in here, or all of these videos on buy-sells, helping accountants, wills and testamentary trust, asset protection. You can see young Tim's got an element up there. So a lot of these areas are sitting up there, built by sell. Enduring powers of attorney, we've got them over all states and also territories. EPOA and will automation. So again, that's a nice little one to do. This is the one that you're probably going to use all the time. You'll see now is I can actually, we've made a change where I can actually select a folder or create a new folder for a client, so I can put it in the conference, and then I can effectively start that, and then I give it a name. So I could put in there, for example, I'll just put in there grants, EOA and will. And then I go through the process, working out the documents there. I've got 3 aspects I can put in. For example, I'm in Queensland, my EPOA. Is this a will and testament? I want a will and testament with this? Absolutely. So then I'll go through there. You can see in our wills, not going to have time to do it, but have a look at the videos. You've got, again, that succession of executors, which really follows up from our succession of our attorneys. You'll see there we've got specific gifts, a child guardianship, pet guardianship, and funeral wishes. We've even got social media in our broader wills and testamentary trusts if we want. Now, if you're an accountant or financial planner, the idea is to tick that box and up will pop a letter basically going to the recipient of the will saying that this has been produced from a data capture and is not legal advice. And also comes with a great letter that Tony has produced going through the execution requirements of that particular will. So look, it's a really, really good package. And when you think about it, I think that both together it's $198. But effectively, if you're in the system, you'll actually have it yourself. And I know we're rolling a lot of these out with Tim, so watch out for July, particularly the accountants out there. For July 2020, we'll be going through a lot of this sort of stuff, talking about how to deal with clients, role-playing, so on and so forth, and make sure that we know where Abbott Mourly fits in, and more importantly, what you can do yourself. But again, I've done a lot of videos on that one as well. So we've got, let's go back and have a look at the other ones. We've also got, for example, here, the LYD will, if you just want to do it yourself, but to me, it's better to actually have that together. Enduring powers of attorney, you've got your LYD will with testamentary trust. Now that one is, if I have a look here, I'll just go into my vault again. I'll go into conference because I've done it before, so you can start to see. So the will with testamentary trust, there we go. So if I go into that one, you'll find that it's much the same as the LYD will, but what it has here is just that little bit further. It covers social media accounts. But when we come around to beneficiaries, for example, I can make Sally, who's my spouse, a beneficiary, and anything that goes to her, or I can do this around specific gifts if I want. So, for example, I've got my interest in my property at this. I could have my investment property going to my son, my child, which is Matthew. Now, what I can do is I can work every time I give a gift or I've got a residual beneficiary, I can create a testamentary trust. And that's pretty powerful because you're not going to see that, I can tell you, in any legal documents you looked at. So the first question is, do you want to set up a testamentary trust? You go, yes. Now, is it going to be automatically transferred in or is it going to be optional? So optional means the executor and the beneficiary, in this case, Matthew, can decide whether they want to put it in testamentary trust, particularly if Matthew's got children. So I could go no, but if, for example, Matthew's a layabout, then I go absolutely yes. Now, do you want the second beneficiary to be bloodline or lineage? So we have a look down. So obviously Matthew's going to be the primary beneficiary, or the principal beneficiary, and then the secondary beneficiary, do you want it to be bloodline? We can choose that. Now, do you want to include related entities? Yes, we can do that. Is the primary beneficiary the appointor? Yes. But if it's mandatory, we'd probably say no, and we might say my executor, oops, I can't even spell, sorry about that. Executor is to be my appointor. Anyway, so we can do that, and then we can start to build. You can start to get involved in that. But there's training up on the site, we can do that. But that's very expensive. Normally that would cost, and if you go to a law firm, you're looking around about $1,800 to $2,000 for that. It's certainly nowhere near as sophisticated. So if I go back to our estate planning and have a look at what we've got. We've also got the moat. So the moat here is something that's even bigger. I'll go into the moat. So again, I'll go to conference. So this is, I know a few of you have been working in on this, but this is, look, a great, where is the moat? You guys are probably seeing it. You know what my bug eye is like. Where is the moat? There it is, the moat. Okay, if I go in there, the moat is, again, it's this is what we're really good at, is the automation. I want to show you something very awesome in a couple of seconds. Now, we set up the documents. First off is the key to any of our long scale documents is to put in all the parties. For example, John Smith, Sally Smith is the spouse, the kids, Max, Jody, Rehab, the kids of the kids, so the grandchildren, Ben and William, any friends or the executors are going to be in there, and also any trustee companies. Because when we come around to do the documents in this one instance, we can do an enduring power of attorney. If you haven't set up a leading member, which we're going to actually call them Family Protection Trust very shortly, you can set that up as part of the deal. If you've got an existing SMSF, then you can upgrade the corporate trustee to a leading member. Remember I talked about a cancellation and then the reissue, we'd do that. Upgrade the SMSFD to the latest one. In fact, I've only just signed off on an upgrade this month. We will be going to annual upgrades from June, if you want to do that, or if you want to get your clients on the annual upgrade process. You can do an SMSF will, and then you can do either last will and testament or last will and testamentary trust. So that's like a pretty big kahuna, but the important thing is go and have a look at me doing it on the video. But once I have got all these nominees or these people, I can go in here and do my last will and testamentary trust. You can see it pops up here. I go through the general, which basically says, well, hold on, is there a life interest? I can go no. Who's the testator? I've got John, but I could equally put Sally Smith in there. So it enables me just to put all these details in really quickly. And it should take, I use this document when I'm dealing with a client. A good thing about Zoom is that Zoom now allows me to talk with a client, ask them the interview questions, it's not that hard, and explain it to them and then just complete it as we go through. Now I've got a bit of, I know the moat really well, but it probably takes me around about maybe 30 minutes to complete with a client. So particularly if the client has already done the data capture for you, which you find in our strategy center. Anyway, you'll find that the other big one that we've got in our little estate planning package and toolkit effectively is, so I've got, okay, so what we've got there is the other one that I've got, and I've got Mick answering all the questions, so good solution there, Mick. So the other one we've got there, which is my favourite, and I know Tim loves it, is the Protector. So the Protector is perfect for any business owner, professional person with assets in their name that may be subject to litigation or may have their estate challenged by family provisions. And essentially what it is it's a gift and loan back to a family protection trust, which essentially is only for bloodline or lineage. So there's a process there. I don't want to go into it, but effectively we use this quite a lot of time, that if a client has got a family home, investment property, shares, all those things I talked about before, if we can determine what the equity is or the net equity is at this present point in time, we can shift that through into a family protection trust and then do a loan back of that equity back to the members. Or alternatively, we'll be coming up with a great solution for trading trusts or business trusts later on when it comes around to UPEs. So effectively what we're doing is we're putting everything and housing it into that trust, remember, because once it's in there, it's completely protected. You can't see a family provision, which is starting to eke out into SMSFs, doesn't go into that family protection trust. Now that's a really great, valuable tool that I know Tim uses all the time, and we've also got now throwing up Queensland mortgage documents, etc. So that's always going to be a great build out for us. But again, that's part of the system. Interestingly, we've just had a bit of an upgrade. You can see with your dashboard here, when you get your dashboard, when you first log in, you've got all your stuff there, but you can see here, I'm on LY Strategist, which means I don't pay, but you can see here, I've got for the month, all the documents that I have completed over that time. So I've probably done maybe about probably about $4,500 of documents that I've done over that month. We've got some guys actually up around about $10,000 or $11,000 per month in terms of their documents. As you can see, there's no payment, but it's a great way to work out the amount of money that you're saving through using us. And remember, we're pretty cheap, or inexpensive, I should say, because we're actually very strategic. very inexpensive in the process. Now, one of the last things I want to do before I leave you is just show you what I've been working on. And you can see here, this is the LYD will for a couple. So I've set one up, I've got common parties there, documents set up. I've gone in there, you put, obviously for a lot of the documents, you want to put the AM logo on there, if it's particularly if it's a will. I've set up all those common parties, remember I said before, and then we go to the general. So I'm going to do the will and last will and testament. I haven't built it for testamentary trust, but this will come out a little bit later on, and also in the moat, and also potentially in the protector. So what I'll be able to do is I'll just simply go yes, and you can see there I've now got 2 wills that are going through that process. So it doesn't take long. Once you've got all the common parties, you can actually start to build. And rather than having mirror wills, the problem about mirror wills is that usually it's like goes from husband to wife and then wife to husband, and that's it. What this does is you're actually doing 2 complete wills and going through the process, because if assets go from one to another, then the other one has started to be bulked up, and we need to start to make decisions around the executors and the successors. And that's really important, both sides of the thing. So we can now do both husband and wife or spouses. We can do both of their wills together. And effectively you'll be available to get that. I'll come and do that next week. In fact, I'm looking at doing it not only LYD couple, but LYD family, so that you'll then be able to do as many family members as you want through this one process, because all the common parties will essentially be much the same, and then it's a matter of just going through each of those. Now, of course, when you print out, you don't have to print out each and every one. You can just print out one, you can print out the next, you can print out the next, and then transfer it in. But effectively, I could do a whole family if they were sitting in front of me or on a Zoom. It would take me probably around about an hour to do a 5-member family, and that's including wills and testamentary trusts and EPOAs. So that's a very exciting development that we've got there. And I think the main thing is that we, if you've been with us for this ride, we've done a lot for this 1 year, and we've got a great team. We've got Mick online, who's our CFO, does some great stuff through I Love Accounting, does a lot of help in our offshoring and for a lot of our members as well. He's built the whole company side of the platform, also the trust distribution minutes, which we're doing a wholesale review at the moment. We've got Ashley, who does all the COO work, and she looks through all the, is building effectively. She's just building this platform all the time. So we get new features virtually every day. I probably need to pull back and say, look, this is what we've done in the last 2 months, because I know you'd actually be blown away on how quickly we're developing, because we've got a really good platform. And there's obviously myself, who creates all the documents. We've got Tony from Abbott Mourly and his team, who are there to help sign off, but he also signs off on all the documents as well. And we've got our template development team over in Manila, also with some of our customer support as well. But funny to say is that if you do put a support ticket on our line, then Michael, myself, or Ash, or anyone, they'll be assigned that ticket. So if it's a technical one, it comes to me. So we've come a long way in a year, but really this is just the start of where we're going in terms of that automation. We want you to we want you to be in a position of punching well and truly above your weight, that you're effectively going to have the tools and resources that are even better than some of Australia's biggest firms. And you can see that's the case with the COVID-19. It's been a great excuse, I saw, for a lot of the legal firms to start to have layoffs. And many of those people may not come back, because law firms are now embracing automation, as you can see that we've been able to do there. Anyway, that's enough for me. And for those of you who want to go down that track, sign up for LYProtect now and start to get involved. Do your own deed, do your own EPOA. Wait for, if you're doing a couple, just wait until next week. Start and have a look at LY, have a look at the LY deal with testamentary trust, or best still, start with the moat, because if you master the moat, honestly, you're not going to need anything else. Everything actually happens to be in there. All I'm going to have to do to make the moat real and really all-encompassing is put the protector in there, which will happen in the next couple of weeks. Anyway, thank you very much for your time today. As I said, watch out for what's coming down the track. And hopefully I'll do a formal launch of LYProtect in the next week or two. But next week we'll be doing that LYD will for the family. So watch out for that one. Anyway, it's Grant Abbott signing off, and thank you all for turning up today, and good luck with everything.